So good morning, good afternoon, or good evening, depending on where you are in the world today. And thank you for joining us on our 5th annual Fashion Law Year in Review. I am Laura Ganoza. I am the co-chair of Foley's Fashion, Apparel, and Beauty industry team, which we call Foley Fab. And I've been hosting this program for 5 years in a row, and I'm excited that you folks keep finding it valuable enough that we keep doing it. So thanks again for joining us. And today we have 2 wonderful members of our Foley Fab team who are their first time. They are co-hosting this with me today. We have Jessica Walker. She's one of our wonderful litigators out in Los Angeles, California. And we're excited to hear from Jessica as she goes over some of the latest case law that we've been following, and also some new case law and some other things we should be watching out for. And we also have Emily Ostreich. She's an associate in our Chicago office and a member of the Trademark Advertising and Copyright Group. And we're thrilled to have Emily here. She's going to talk to us about some trademark matters we should all be aware of, as in addition to some legislative issues. So we have a lot to cover here today. First, like as we do every year, is we give you an update on our cases to watch section. We usually end our webinars with cases that we're going to watch for you or that you should be watching throughout the year. So we're going to give you an update on a couple of those that we've been watching. We're also going to tell you about some new cases that happened in 2022. A lot of cases happened in the fashion industry, and we're just going to go over a few of them to make you aware of some issues that you should just know about as you go forward in this practice. And as always, we're going to cover some hot topics. And nowadays, you can't cover hot topics without, of course, covering the metaverse in some way. So we will be talking about that. Another thing you can't cover in fashion without talking about is sustainability. And we'll talk to you about some updates that you need to know about that. Also, the Copyright Claims Board is a new mechanism by which some copyright owners are seeking to enforce their copyright rights outside of federal court litigation. This was a new program, and Emily's going to give you a little bit of insight of what's going on with that. As always, we have some legislative news. And of course, another topic this year is collaborations gone wrong. I think we could all learn from some of the things that's been happening in this last year to tighten up our collaborations. And finally, last but not least, we'll give you some cases to watch for 2023, which we'll definitely be watching and which we think are important for you to watch as well. So without further ado, I'm going to hand it over to Jessica so she can give you an update on some of the cases we've previously watched for you guys from last year.
The first case that we left you with last year that we wanted to talk about today is the Peloton versus Lululemon case. This is a dispute that arose out of an original co-branding partnership between the 2 brands that then ended when Peloton ended its own partnership with Lululemon, launched its own apparel, including a number of sports bras and other products that Lululemon asserted violated its own design patents and its own trade dress. In response to the cease and desist letter that Lululemon sent, instead of responding to the cease and desist letter, Peloton went ahead and filed its own lawsuit in the Southern District of New York seeking a declaratory judgment. Lululemon followed up with its own lawsuit in the Central District of California. And where we left you last year was with a pending motion to dismiss in the Southern District of New York, in which Lululemon asserted that the Peloton action was an improper anticipatory action that should be dismissed in favor of the case filed in the Central District by Lululemon. This, of course, is important, the anticipatory action issue, as an exception to the first filed rule. So whereas typically cases go forward in the forum in which the case is first filed, by arguing that this was an anticipatory action that was improper. Lululemon was saying, ignore the fact that Peloton filed first. This should really go forward in our chosen venue. This motion was granted in September of 2022. The Southern District of New York decided that under both Second Circuit law and Federal Circuit law, this was an improper anticipatory action warranting dismissal of the Peloton case. And the court focused on some key features that were in the Lululemon cease and desist letter. First, it focused on the fact that Lululemon's letter informed Peloton, we're going to sue you in federal court if you do not comply with our demands. So it was very clear that it was leading up to a lawsuit. Second, Lululemon's letter specified particular causes of action. So here, patent claims, trade dress claims, trade secret claims. And third, the letter provided a specific deadline by which Lululemon expected Peloton to comply. Another factor that the court relied upon was its finding of bad faith on the part of Peloton. When Peloton received the letter from Lululemon, which did set forth the deadline, Peloton responded and said, hey, we need more time. Could we have an extension to X date? Well, on that date, instead of responding to the cease and desist letter, Peloton filed its own lawsuit in the Southern District of New York on that day. And in analyzing where the lawsuit should go forward, the court also found that the balance of convenience factors didn't really favor either party. So the fact that this was considered an anticipatory action just made the decision for the court. So some key takeaways here. If you find yourself in the position of sending a cease and desist letter and want to make sure that you're preserving your ability to have a case heard in your chosen venue or forum, these are great details to make sure that you're including specific intention to file suit if you're not, if you don't reach an agreement, if you don't have compliance with your letter, specifying what causes of action you're planning on bringing, and providing a particular deadline. So it's not an amorphous cease and desist letter, but has an actual schedule set forth. And if you find yourself, as Peloton did, in receipt of a cease and desist letter, avoiding behavior like asking for an extension and using that time to file a lawsuit instead of engaging in a back and forth in response would be good to avoid. Never good to find yourself having a court make a ruling that you engaged in bad faith. So important factors here on either side of a cease and desist situation that you should keep in mind going forward. Interestingly enough, so the Southern District of New York granted the motion to dismiss on September 29th, 2022. The very next day, September 30th, Lululemon dismissed the Central District of California action, stating that the parties had reached an agreement. So it seems like the parties had reached a settlement while still waiting for the court to decide on this motion. So the case is over. No more litigation will happen here. But it leaves us with some good takeaways on best practices in a cease and desist scenario and when you're considering when to bring a declaratory judgment action or not. The next case that we discussed in detail last year that we wanted to bring everyone's attention back to is the pending Hermes versus Mason Rothschild case. Rothschild is an artist who created the Meta Birkins NFTs, which are these furry, fuzzy renderings of the famous Birkin handbag. These are NFTs that Rothschild sells and has profited from as well. Hermes had sent Rothschild a demand letter and said, this infringes our trademarks and trade dress. We need you to stop. He did not, and so ultimately a case was filed against him in January of last year. The causes of action are pretty straightforward: trademark infringement, false designation of origin, etc. Rothschild's defense all along has been that this is protected by the First Amendment. He claims that this is an artistic comment on the absurdity of the Birkin handbag, on the animal cruelty inherent in making leather handbags, and he claims that his fanciful depictions of furry handbags that don't exist have minimal artistic relevance. Over the past year, the Southern District of New York denied 2 motions to dismiss brought by the Rothschild. finding that Hermes had sufficiently alleged that Rothschild's use of the trademark was neither artistically relevant and was, in fact, explicitly misleading. Rothschild sought to appeal the motion to dismiss order interlocutorily, and the court denied that request. Both parties moved for summary judgment, and the court denied both of those. It was a very short order stating that the court would not be granting either motion, that the case would go to trial. The court had promised us all an opinion explaining the summary judgment rulings by January 20th, and then it got pushed to January 24th. Unfortunately, as of this morning, there's still no order explaining that, so we're still watching for that. But excitingly, jury trial began yesterday on January 30th. Some key updates from the beginning of trial yesterday. A lot of motions in limine were pending in advance of trial, including motions on each of the parties' experts. The court excluded Rothschild's expert, who was an art critic who studied and wrote a biography on Andy Warhol. The expert had opined in pretrial discovery that the Meta Birkins were business art in the same vein as Andy Warhol's Campbell Soup silk screen prints. Hermes had moved to exclude him, arguing that there was really no reliable data or clear methodology underlying this expert opinion, and the court agreed and excluded this expert. So this is potentially very crucial to determining what Rothschild is going to be able to put forward. From the very beginning of the case, he has asserted an analogy between himself and Andy Warhol and saying, this is exactly the same. This is my, transformation of a well-known image through my imagination. So it'll be interesting to see how the case continues without this expert. At the same time, the court also excluded testimony of a French lawyer that Hermes was going to put forward to testify about confusion in the marketplace. So rulings going kind of both ways there. During opening statements, Rothschild's counsel again leaned into that Andy Warhol analogy very significantly, arguing that this is, the same kind of project that Andy Warhol is well known for. Hermes, meanwhile, shared messages that were sent by Rothschild asking people to pump and shill his images for the sale of his NFTs, and joking that if he received a cease and desist letter, he would make an NFT of that as well. So seeing some themes here of one side arguing, oh, this is art in the vein of a really famous, well-known artist, versus the brand asserting this was the work of somebody trying to make money off of a trademark that he doesn't have the right to generate money from. So it'll be really interesting to see how the rest of that jury trial goes and how that turns out coming up. Laura.
Thank you. So coming from one case that has moved fairly quickly through the court system to another case that we've been following, I think maybe for 3 years now, the Chanel versus What Goes Around Comes Around case that's also pending in the Southern District of New York. And as a refresher, What Goes Around Comes Around is an online marketplace that sells secondhand secondhand products, including secondhand Chanel bags. And back in 2018, Chanel filed a lawsuit against What Comes Around Goes Around, and also we'll talk about next The Real Real, claiming that the way that they market these products on their website and the fact that sometimes they aren't authentic, it violates their trademark laws. So Chanel sued for trademark infringement, false advertising, false association, and under New York's own business law, unfair practices law. And one theme you'll hear a lot that we're talking about this year is, consumers and are recognizing the importance of sustainability efforts in in fashion. They're looking for ways to upcycle things, to recycle things, to repurpose things, to buy secondhand things to kind of curtail their footprint in the fashion industry. So this case is really important in terms of the resale market and nominative fair use in the resale market. And so kind of what's going on now is that the parties had filed motions for summary judgment, and on March 28th, the court denied in part each party's motions. First, it granted Chanel's motion for summary judgment on trademark infringement as to certain products. It found that, so Chanel's complaining about over nearly 850 bags that they contend are not genuine. So of those, 12 handbags were found to be non-authentic, and the defendant was found liable for trademark infringement of those bags, including one of the bags that had a serial number that was fraudulent, because through serial numbers is a way that Chanel maintains and tracks authentic bags, and one of them had a false serial number. At the same token, the court granted some of what comes around goes around defenses and claims. Specifically, the court found that Chanel was unable to prove the New York state law claims because you need something more than just ordinary trademark infringement. Under this specific law in New York, there has to be a specific injury to the public interest beyond just ordinary trademark matters, trademark infringement. And the court found those usually are relating to cases like it's danger to the public or some kind of health and safety, and Chanel was not able to do that. So I checked the docket earlier, and it looks like the parties are going to try to mediate the case. Mediation is scheduled for March 6th in this case, but it's going to be really interesting if the case is not settled at mediation and there's ultimately a substantive decision. Really, it's going to be what is the scope of what a reseller can say or not say in terms of how they advertise another party's products. And I think that's going to be really informative going forward, because I think these secondhand markets are just going to continue to grow. And here's another one that's currently pending as well. It's the same kind of case, Chanel versus The Real Real. The Real Real is another marketplace where you can buy secondhand luxury goods, and Chanel also sued them. These parties also, in this case, the parties also tried to mediate the case, and they were not successful in resolving it. So where we left you last year is I think the parties were arguing over whether The Real Real could amend its counterclaim to assert that Chanel was engaging in antitrust violations and an anti-competitive behavior. One of the things that The Real Real is trying to argue is that Chanel allows certain resellers to operate in the resale market without similar authentication requirements, but it only does that with companies that are related to Chanel or which somehow profit Chanel in some way. Chanel has moved to dismiss the counterclaims and the affirmative defenses relating to that. The court hasn't ruled on that motion to dismiss, and instead the court's actually stayed discovery on that issue until that dispositive motion is ruled on. And again, this is just another case that we think is really important to determine what a secondhand dealer can and can't say. And it's interesting because the what comes around goes around case actually was citing The Real Real case in some of its motion for summary judgment briefing. But the court in the what comes around goes around case noted that in all cases, The Real Real did not use the Chanel font in a larger font than The Real Real's own font, and that it was always the same size as all of the other brands that were advertised. Whereas there's still some issues in the what comes around goes around case, because they seem to send out advertisement that either just involves Chanel, or in certain cases, the trademark use of the Chanel logos is larger than the what comes around goes around old logo. So it's interesting to see how one case is citing the other. But hopefully we will get some resolution on these sometime in 2023. And now I'm going to pass it over back to Jessica, who's going to tell us about some other 2022 cases that we've been following.
The first case here is a case filed by Nike at the beginning of 2022 against StockX that has some similar themes to both the Metaverse and NFT case and the resale cases that we just talked about. StockX is an online marketplace that sells sneakers and apparel with a heavy emphasis on collector edition sneakers, such as Air Jordans and the other kind of sneakers that people in the old days would just line up in person to buy. Now they can line up online for. Last year, in January, StockX launched its own Vault NFT program through which it sells digital twins, which are considered NFTs that correspond to specific physical items. So these are not just abstract NFTs like the Meta Birkins, which do not correspond to an existing physical, tangible piece of property. Instead, these are NFTs that relate specifically to an exact physical match that, in this case, StockX has in its inventory. And this program allows consumers to purchase and sell that digital twin. And then when they're ready to, when whoever in the buying chain is ready to, they can redeem that digital twin NFT for the specific set of sneakers. The NFTs have pictures of the sneakers at issue, which of course, in the case of Nike, have not only the designs created by Nike, but the swoosh logo for Nike. And so Nike has filed a complaint as of February of last year, alleging trademark infringement and trademark dilution for the use of Nike's marks without permission. StockX's response is that this is nominative fair use, and it is argued that it's necessary to use the Nike marks to represent its own inventory, that it did not use more of the marks than is necessary, and that it accurately portrayed the relationship between Nike and StockX. Case is still going on. Fact discovery is scheduled to close at the end of February this year, so it'll be very interesting to see what develops, what motions for summary judgment might come out of this. But it's interesting because we've got we've got the full spectrum, right, of NFTs that are asserted to be artwork independent from the underlying products that they kind of represent or reference. And here linking to inventory. So again, going back to the resale question of when can you present marks based on stuff that you own. The next set of cases are upcycling cases that were filed this past year. Instances where luxury designers have brought cases against designers that are upcycling old, previously sold items into new artwork, jewelry, etc., and creating new work. So, for example, Louis Vuitton filed a lawsuit against a jewelry designer who used identifiable pieces of handbags and other items into new works of art. Chanel also had a case against a company that was using buttons with recognizable CC monogram trademarks on them. What's interesting here is, in general, the first sale doctrine says that you can do whatever you want with a handbag or a button once you own it. But because the designers here are making new upcycled products, the question becomes, is this materially different such that it creates a trademark issue? Both of these cases settled with permanent injunctions, with the designers saying that they are not going to do these upcycling projects going forward. But it's going to remain an issue. Again, going back to sustainability, consumers want to see things that are reused. So where is that line here between reusing things and stepping on the trademark rights of the original brands? Turning it back over to Laura.
Thanks, Jessica. So I'm sure a lot of you have probably already heard about this recent verdict that was just reached in the ongoing dispute between Adidas and Thom Browne. Adidas is a vigilant enforcer of its 3 stripes trademarks, and it sued Thom Browne in connection with his 4 stripes that he calls the 4 bars that he puts on the left-hand side of the sleeves and his and of the pants. Now, what's interesting about this case, it was I pulled the verdict, and it was, basically 4 questions. Did Adidas prove its trademark infringement, and if so, the damages, and was the defendant liable for dilution? And in both those cases, the jury found that Thom Browne was not liable. And what's interesting in this case is that this wasn't the first time these two tangled with each other. Apparently, back in 2006, when Thom Browne was still kind of a new designer, he was using 3 horizontal bars. And Adidas contacted him and said, hey, you can't do that. We have these 3 stripes. So he came up with the 4 striped bars later on and started using it as of 2009. And he claimed he was peacefully using this, and he was surprised that in 2001 Adidas took this position and told him to stop. So I think this case is interesting in terms of, when you have facts like that and you bring a case, it's really important, I think, to always kind of know who your defendant is when you're going to bring a case like this. Because one of the claims Thom Browne had was it sought to cancel Adidas's claims, Adidas's marks, claiming they were aesthetically functional. Ultimately, the judge denied that, but their trademarks were kind of on the line there in this case. And it's interesting, it's Judge Rakoff in this case as well. He's the one handling the Hermes trial. So he's been pretty busy in the fashion industry cases this year. I'm going to hand it over to Emily now, who's going to talk to us about an appeal from a trademark trial board decision.
Thanks, Laura. So a little over 2 months ago almost, the Trademark Trial and Appeal Board affirmed the rejection of Timberland's product design trade dress for its iconic work boots. And so for some background, in 2015, Timberland filed a trademark application for lace-up boots consisting of a 3D configuration of various features, some of which include the sole design, the 2-tone color of the boots, and the hourglass shape. The USPTO examiner examining the application rejected it and claimed that the product configuration features were non-distinctive and that the mark comprises functional trade dress, which is not registrable. Despite advertising the boot for more than 3 decades, the TTAB affirmed the USPTO's rejection and held that the boot design lacked distinctiveness. So this is really a double whammy for Timberland. And it also affirmed the USPTO's refusal on the grounds of functionality and found that some of Timberland's now expired patents and Timberland's own advertising touted the functional benefits of the features at issue. And so for some key takeaways from this case are that sometimes long-standing advertising may not be enough to obtain acquired distinctiveness. A lot of times brands think that they might be able to get away with an acquired distinctiveness claim based on advertising. However, this case shows us that that's not necessarily the case. And also we can take away the fact that prior filed IP and a brand's own advertising could be used to rebut certain claims before the USPTO or the Trademark Trial and Appeal Board. So it's definitely important for brands to be sure that whatever they are claiming in prior filed IP or advertising is useful and wouldn't be used against them in the future. So now we're going to move away from case law for a bit, and we'll talk about hot topics in fashion and related legal considerations. And like Laura mentioned earlier, we can't talk about hot topics in fashion without mentioning the metaverse. So that is our first topic. We touched on the metaverse last year, and back then brands were still kind of getting their feet wet and deciding how and even if they were going to enter the metaverse or enter the NFT space. And now that the metaverse has continued to gain popularity, we've seen many different brands get involved in a variety of ways during the past year. As a refresher, most of us are familiar with, or we've heard of the metaverse and NFTs by now, but for those who are not as familiar, the metaverse is essentially an interactive, creative, digital environment where people can work, play, socialize, and even shop these days. So some ways that brands have recently entered the metaverse in the past year include gaming, include through NFTs, and also the first Metaverse Fashion Week was held. So for example, gaming. Brands like Balmain partnered with gaming brands like EA and their game like Need for Speed Unbound to drop a series of limited in-game wearables. And so a lot of times people who play these games are able to go in, choose their avatar, and choose what they wear. And so Balmain, when it partnered with Need for Speed, included some of its wearables from its fall 2022 collection. Brands have also started releasing their own NFTs, which are non-fungible tokens that are exchanged in the metaverse and obtained with cryptocurrency. So an example of this is Prada joining forces with Adidas for a limited NFT collection called Adidas for Prada Resource. And this project brought together 3,000 randomly selected participants from numerous different industries like fashion, design, and crypto. And they were tasked with creating individual NFT tiles that were eventually compiled into one single NFT and auctioned on the site Super Rare, which is an NFT art marketplace. And then finally in 2022, like I mentioned before, we saw the first Metaverse Fashion Week, which is really exciting and a very different and interesting way to get involved in the metaverse. And this was hosted in the 3D virtual world Decentraland. And the virtual fashion week consisted of 4 days of virtual runway shows, panel discussions, and of course, shopping. There were various brands that were involved, and a few of these with bigger names include Tommy Hilfiger and Roberto Cavalli. And because the virtual Metaverse Fashion Week was so popular in 2022, Decentraland is again hosting it in 2023, and this year it will be from March 28th to the 31st. So we'll probably see similar runway shows and panel discussions, but there might even be some new features. So we're going to be watching that one throughout the year. So next, to show exactly how popular the metaverse has become, we pulled together some statistics that compare the total number of NFT and metaverse trademark filings in 2021 versus 2022. So as you can see, the number of NFT and metaverse applications more than tripled between 2021 and 2022, which is really shows exactly how popular NFTs and the metaverse are becoming and how brands are starting to engage more with it. NFT filings actually peaked in March 2022 with around 1,050 filed, and metaverse filings also peaked during this time, but only around 700 applications were filed for metaverse filings in March of 2022. And despite these high numbers in March of 2022, we actually have now started to see a decline in filings, and this could be for various reasons. It could be because the trading volume of NFTs has started to decline, specifically around September 2022. It started to wane a bit. Or it could be that the popularity of NFTs in the metaverse is wearing off. Only time will tell, but it'll be interesting to see if these filing numbers pick back up in 2023. So next, we are going to talk about the Nike Metaverse filings. And last year, we actually touched upon this, and we wanted to give an update for this year. And as a refresher, Nike filed an intent to use application for the Nike wordmark in classes 9, 35, and 41 for virtual goods and services. The application is still pending before the USPTO, and actually the examiner recently approved the application for publication, but the USPTO stepped in and decided that there needs to be further review before it's actually published. So the mark is still unpublished, and at this time it's not clear what exactly the USPTO believes it needs to review further before it can be published. So it'll be interesting to see the USPTO's take on this and why it kind of withdrew the mark from publication. During the initial examination process of this filing, the examiner did require Nike to add a couple of phrases to their goods and services identifications. Specifically in classes 9 and 35, it required Nike to add the phrase "in online virtual worlds." And then in class 41, it required Nike to add the phrase "created for entertainment purposes." Nike agreed to both of these changes, and so the applications moved forward. Nike in 2022 also filed for 10 additional Metaverse filings, bringing its total active Metaverse filings to 23. And in addition to these filings, in November 2022, Nike launched its own Metaverse platform, .swoosh. And through this platform, consumers are able to build their own collection. They can display it, they can trade it, or they can use the designs that they create in games and other immersive experiences. So clearly Nike has big plans in the metaverse, and it's really starting to enter and gear up into getting more involved. So it'll be interesting to see exactly how their trademark filings have any impact on these plans. Moving on to another brand that has recently entered the NFT space is Tiffany & Co. And they entered the NFT space through their NFTIFs. And so back in August of 2022, Tiffany launched the NFTIFs, which is essentially a collection of 250 passes offered to owners of CryptoPunks. And if you haven't heard of CryptoPunks, they are a unique characters on the blockchain, and they're generated by computer code. And because of this, each CryptoPunk is different, and no two are the same. So the owner of a CryptoPunk can buy an NFTIF for around 30 ETH, which at the time in August of 2022 was equivalent to around $50,000. And in return, Tiffany & Co. would create an 18-karat yellow gold or rose gold pendant inspired by this person's CryptoPunk. And alongside the pendant, Tiffany & Co. would also provide the CryptoPunk owner with an NFT of the design as well. So in true Tiffany & Co. fashion, the pendants will feature at least 30 stones, some of which could be diamonds and other gemstones like sapphires or amethysts, just depending on the design of the CryptoPunk. And they will come with an 18-karat yellow gold or rose gold chain, depending on what that what the material of the actual CryptoPunk is made of. And so NFTIFs are expected to ship in early 2023. So I looked recently, and there was really no information about whether they've shipped yet in January, but they should be shipping very soon. And this is a really interesting example of a brand entering the NFT and metaverse space because it shows a high-end luxury brand that's still staying true to what they're known for, which is making jewelry. And so Tiffany is not just going into these virtual worlds and providing skins and virtual jewelry for avatars, but instead they're actually making their jewelry, but also playing off of the NFT and the metaverse space. So moving on from the metaverse, I'll hand it back over to Laura to talk about sustainability and fashion.
Thanks, Emily. So, of course, sustainability is big in fashion, just like the metaverse, but sustainability is just as big. Consumers, especially younger generations of consumers, are really concerned about the environmental impact that their purchasing decisions have. And as fashion being, one of the largest polluters on Earth, they're especially attuned to that. So sustainability is obviously an issue that is a hot topic, and it's going to continue to grow. And brands are recognizing that, and so they're trying, some successfully, some not, to make their products more sustainable, or at least they're advertising it as such. So one thing we wanted to make sure to mention is something a lot of us have been waiting for that are in this space is to see if there's actually going to be an update on the Green Guides. The Green Guides, they were actually created by the FTC back in 1992 in order to help businesses avoid making false claims as it relates to environmental marketing and advertising. They've been amended here and there, but the last update was in 2012. So a lot of people were saying, it's really time to update these green guides. A lot of more people are entering into markets with sustainable products and advertising it to consumers. So recently, on December 20th, the FTC said, okay, we are looking for public comment as we update these green guides. And there's several things that they specifically want the public to comment on. One is carbon offsets, or what people can say about a product having net zero impact or carbon neutral impact. That's one. But I think what's really important, and I think what people are waiting for in the fashion industry, is that the FTC is also calling on the public to help them with the terms organic and sustainable. Back in 2012, when these guidelines were last updated, the commission decided not to address these guidelines as it relates to claims that products are organic, and decided the same thing for sustainability. It determined we don't have enough of what we need to make these guidelines for it. So hopefully the FTC will issue some guidelines to that effect, because those are words that brands, especially in this space, are using. So public comment period ends on February 21st, 2023. If you're interested in being heard, go onto the FTC website and you can make your comments. Now, the Green Guides are just that, they're guidelines. They in and of themselves are not enforceable, but they are helpful in terms of, helping a brand or even a consumer recognize what is considered false and what isn't. States have also incorporated some of this. It can also be used as a defense. So it's really important, once these guides are updated, and we hope that they will be, it's going to be important on and have a large impact on the claims that you make. And the reason it's going to be is because you want to avoid greenwashing. And greenwashing is something we've been hearing a lot about lately. Companies are being sued about it. But essentially, it's when a company makes a claim about its products that they are sustainable or eco-friendly, when in truth they're not. So they're basically making misleading claims about these characteristics of their products. And it's especially in this climate, no pun intended, with consumers really interested in how products are being made and their effects on the environment. These kinds of cases are, just going to garner, more attention. But brands are still out there, and they're trying to make these claims. Recently, Amazon came out with Amazon Aware, which is supposed to be a small group of products that are to be considered more socially conscious, environmentally conscious, more sustainable. It got hit with some backlash because while they're saying that these particular products are made in that way, some of the products are still shipped in, plastic containers, and, multiple packaging is used with them. So they got some backlash with that. And H&M was recently sued in a class action complaint in the Eastern District of Missouri, claiming that they have this new conscious collection set of garments. And they were sued claiming that you're claiming that this is more sustainable, but it actually isn't. You still use synthetic fibers and items that are not friendly to the environment. This case was recently filed. It was filed in November of 2022, and H&M just recently filed a motion to dismiss. And the defense that H&M is using is that they're saying that this collection is more sustainable than comparable garments that they sell, specifically at least 50% more sustainable than their other garments. But what does that lead a consumer to believe? If maybe their other garments are not sustainable at all, is that sufficient? It will be determined, because this is still just at its inception. So this will be one to watch for us as well. Now I'm going to hand it over to Emily to talk about some copyright developments.
So a development in the copyright world in 2022 is that the Copyright Claims Board established the Copyright Alternative and Small Claims Enforcement Act of 2020, back in 2020. And then the new development in 2022 is that the CCB started hearing cases in June. And the CCB is a 3-member tribunal where copyright claimants can resolve copyright issues involving up to claims of up to $30,000. Before the CCB was created, claimants would have to go through federal court to litigate any type of copyright claim. And so the creation of the CCB is very valuable, as it's more cost-effective and more efficient than litigating in federal court. The CCB does have limited jurisdiction and hears cases involving copyright infringement, declaration of non-infringement, and claims of misrepresentation and notices sent under the DMCA, as well as a few other types of claims. Once the CCB issues a decision, this precludes parties from filing the same claim in federal court, which is expected. And to bring a claim with the CCB, you either need to have a registration from the Copyright Office or have submitted an application to register the work. And so how does the CCB intersect with fashion? Smaller brands and designers may be more inclined to use the CCB, since it provides a faster resolution and for a lower cost than litigating in federal court. And it also may be useful for fashion designers or brands that don't have a registration yet, but that have filed a copyright application, since you're able to file a CCB claim with just an application. It could also be useful for paparazzi, who we see routinely file copyright lawsuits against celebrities for copyright infringement over the unauthorized use of their photos on social media. Oftentimes, paparazzis have paparazzi agencies, but sometimes they're freelance people, and they don't have the funds to necessarily go through federal court. So anyone who's utilizing the CCB should be sure that they're complying with the Case Act. And this is because 68.6% of the CCB's 102 closed cases were dismissed on the basis that these claims didn't comply with the Act. So it's really important to make sure that you're complying so that your case doesn't get dismissed. So now we're going to move on to talking about fashion legislation in 2022. And the first act that we're going to talk about is the New York Fashion Workers Act. And this act was introduced on March 23rd, 2022. Currently, the act has advanced out of the Senate Labor Committee, but it failed to receive a final floor vote in last year's session. So it'll likely be considered in the current legislative session, and we'll see if it is able to advance this time. the act will create regulations for model management companies and creative management companies, and it aims to protect labor protection for figures designated as independent contractors, such as runway models, makeup artists, stylists, influencers. Requirements of the act center on things such as payment, contracts, and disputes, and some examples include that companies will be required to pay models and creatives within 45 days of completing a job. And also companies will be required to provide models and creatives with copies of contracts and agreements. And now I'll turn it over to Taylor to give the CLE code.
Thank you, Emily. At this time, I will announce CLE code for our program. For those seeking CLE credit today, please record the following 5-digit code on your attorney affirmation form, which can be found in the resources widget on the bottom right hand of your screen. The CLE code is F as in Frank, A as in Alpha, D as in Delta, A as in Alpha, and the number 8. Again, that is F as in Frank, A as in Alpha, D as in Delta, A as in Alpha, and then number 8. I will turn it back over to you, Emily.
Okay, thank you, Taylor. So the next bill that we're going to talk about is the Fabric Act. And this bill is currently sitting, but it affects fashion brands and retailers and is touted as the first federal fashion bill. And essentially, it proposes incentives to accelerate apparel manufacturing in the U.S. and provide new workplace protection for garment workers who are generally paid per piece. So this bill aims to change that. Next, I will hand it over to Jessica to talk about MOCRA.
MOCRA is the Modernization of Cosmetics Regulation Act, which was just signed into law at the end of December 2022. This significantly expands the regulatory oversight by the FDA of cosmetics since the initial FDA Act in 1938. So there'll be a number of areas where cosmetic companies will now be required to register and follow certain product requirements, including having good manufacturing practices and reporting adverse effects. So keep an eye out for the FDA issuing regulations in line with this law that will substantially affect any manufacturers of cosmetics here in the U.S. Also on the horizon is a proposed regulation from the FTC that would abolish employee non-competes across the U.S. So this would not affect business-to-business non-competes, but would make essentially any employee non-competes invalid and considered an anti-competitive action under the FTC Act. This can have a big impact on designers in the fashion space. So this is currently under the public comment period and through March. So something to keep an eye out if it affects you and your current practice on non-competes. Laura.
Thank you, Jessica. So I'm going to go through this just really quickly, just because it's a reminder with, some of the high-profile scandals that we've seen, like with Kanye West and some of the brands that had to break up with him, including Adidas. It's really important to review your collaboration agreements. Take a look at your morality clauses and what kinds of circumstances are permitted for a brand to terminate the collaborator. It's really important when you see what could happen to a brand when it's associated with someone who's, come under fire for offensive remarks and just, kind of creating, in the case of Kanye West, the chaos that he created. So this does give us a chance to kind of go back, look at your collaborations, make sure that there is sufficient language in there to give the brand all the authority it needs to get out when it should. Also, another one we just wanted to mention was Balenciaga, which had its own issues with Kanye, but the scandal that came from its most recent campaign, that it had children with teddy bears and bondage gear and documents showing the decision, the Supreme Court decision on child pornography. Balenciaga got a lot of backlash because they said they were going to sue the advertising company that came up with this, but at the end of the day, it's the brand who needs to have final approval. And so it's really important to, make sure your brand does have that final approval so these kinds of things don't happen. Now we're gonna go to some other cases to watch in 2023, and Jessica's gonna tell us about those.
The first one is a pending criminal case against Nancy Gonzalez, the luxury handbag designer. She's been subject to an indictment in the Southern District of Florida for charges of smuggling and conspiracy for bringing handbags made from various reptile skins in violation of the Endangered Species Act. Gonzalez and her two employees were arrested and are facing extradition to the U.S. in Colombia. This is just fascinating because you don't see a lot of criminal charges coming out of fashion. And it's also notable, this is a very high-profile designer who supplies celebrities and high-end department stores. So it should be fascinating to watch what happens here.
So now we wanted to talk about two recent cases that deal with fashion and biometric information. The first is a class action, Gilo et al. Versus Pandora Jewelry. And this was filed in November of 2022. And it alleges that Pandora, the jewelry brand, collected online shoppers' facial biometric data through tools that we have now that allow shoppers to try on pieces of jewelry and other types of accessories and clothing. And it claims that Pandora violated the Illinois Biometric Information Privacy Act because it failed to get consent from customers and failed to inform them about necessary information about how their data was going to be used. So this case is currently pending in the Circuit Court of Cook County, Illinois. And the next related case that we have is Terrio versus Louis Vuitton. And this case is also based on an alleged violation of the Illinois BIPA Act. And here, Louis Vuitton used a similar tool that Pandora used to allow their online customers to try on sunglasses. And essentially, customers were alleging that the company violated sections 15A and B of the BIPA. On December 5th, the court granted Louis Vuitton's motion to dismiss the 15A claims, but it denied the motion to dismiss the 15B claims. And these are interesting because they involve the biometrics issue, and we'll likely see more cases in 2023 involving this issue simply because these tools became really popular during the COVID-19 pandemic since it allowed people to try on things at home instead of in the store. So now I'll hand it over to Laura to talk about another recent case, which is the Jack Daniels case.
So we'll talk about really quickly two cases that are up in the Supreme Court. I'm going to talk about the Jack Daniels versus VIP case, or the Jack Daniels versus Bad Spaniels case, and it involves Jack Daniels suing a dog toy manufacturer over claims of trademark infringement, claiming that the dog toys that they sell are pooped themed and that they violate their trademarks and dilute their brand. The Supreme Court has decided to take this on, and there's going to be oral arguments in this case in March. But in the meantime, a lot of fashion brands have chimed in. There have been a bunch of amicus briefs, including from Levi's, Patagonia, Nike, and the American Apparel and Footwear Association. Obviously, even though this is a beverage case, it has implications on the fashion industry. Many of us can remember the Louis Vuitton case where the dog toys that parodied Louis Vuitton were permitted to proceed. So we're definitely going to be watching this case because it too can have implications on additional items like this in the fashion industry. And Jessica, why don't you tell us about another Supreme Court case we're looking at as well?
Yes, the Andy Warhol Foundation versus Goldsmith case is pending. Oral argument happened in October. This is the first non-software fair use case the Supreme Court has heard in over 20 years, so significant on that front. And this is about a portrait taken by the photographer Lynn Goldsmith of the artist Prince, and images created by Warhol in his pop art style based on that portrait. The foundation has argued that this creation of the illustration based on the photograph gave it new meaning and was transformed. The Second Circuit below held that a court cannot consider the meaning of the accused work when it's recognizably derived from the original work. This is a circuit split with the Ninth Circuit, and also contrary to prior holdings by the Supreme Court, which have held that works of art can be transformative whenever they convey a different meaning. So the decision, which we expect later this year, will be significant because it will apply to a lot of situations where fashion often incorporates protectable design elements into something new. So seeing which test applies to a transformative work will be really important to keep an eye on going forward. I think our next case is Emily.
So finally, our last case in the cases to watch in 2023 is Nike versus Usa Pe Llc. And this case was just filed on January 25th, last week. And Nike filed the trademark infringement and dilution suit against BAPE, which is in the District Court of the Southern District of New York. And in this lawsuit, Nike claims that 5 of BAPE's products infringe its trade dress for its Air Force One, Air Jordan 1, and Dunk sneaker designs. This might not be a surprise to some people because BAPE has been around since around 2005, and Nike's been aware of this, but it claims that BAPE's infringing was de minimis until 2021, which is why it just now recently filed a lawsuit. So it'll be interesting to see how this case plays out, and particularly with respect to how the court rules on possible defenses like acquiescence or latches or estoppel. And so this concludes our cases to watch in 2023. So I will hand it back over to Laura.
Thank you so much, Emily, and thank you, Jessica, and thank you all for joining us. I know a few of you had some questions. We will make sure to answer all of them after the webinar. We're sorry we didn't get a chance to address them during the webinar, but there was a lot of material to cover. And speaking of that, I'm also going to preview that Foley is going to be issuing for the second year in a row our What's Trending in Fashion Law articles. That should be coming out in the middle of February, and it's going to touch on some of the things we spoke about today, as well as some other kind of hot topics that you should be looking out for or that are trending in the fashion, apparel, and beauty industry. So make sure you be on the lookout for that. And please do write up the survey. Please let us know if there's any other topics you'd like to hear about. We'd love your feedback on that. And thanks again, everyone, for joining us. Have a great rest of your day or night.